Good afternoon and good morning, good evening, depending on what time you actually get to see this presentation, right? About the understanding the role of independent trustee. But you'll see that we actually also touch on the roles of the other trustees, which are similar to independent trustees. We're just trying to sort of the logic and the objective of this presentation is to ensure and educate you on what is independent trustee from the legal perspective and why is it so crucial also from legal perspective. But the reality also is that you will see later on that when it comes to functionalities and when it comes to a certain legal framework is that the trustees are all the same. My name is Shilipo Mutiba. Let me introduce myself. I'm a co-founder of Intergen and I'm the head of tax at Intergen. I'm also a managing director of TaxAid, which is also a tax consulting firm and accounting practice. So now let's go on this journey with me, and then I'll also obviously be introducing myself. You can see here, there I reference head of tax at Intergen, which is our main operating business. That's why you are able even to have access to this presentation that is reserved for you. These are my credentials, and that's why we're so passionate about being academic at the TaxAid and Intergen Private Wealth. Thank you so much for taking opportunity and being our client and valued client. So let's go with the presentation. What are the outcomes on this discussion? You will see that I want to create awareness. I say beware of these particular issues and say, why trust? Why are you even having a trust? Do you even understand the notion, or rather the formation of the trust notion, rather, to say why trust actually exists? What is that critical notion around formation of trust? So that's what I also want to bring. What have been the court cases lessons? That there's just so much that you can learn from court cases around trust. But I will just highlight those I think that are crucial, especially when it has to do with the notion of the trust formation. And then some of the common mistakes that we do during the administration of the trust, we'll also just briefly look into that. The whole notion of independent trustee, where it comes from. Yeah? So we'll look into that. One thing that is, by the way, byproduct that I think that it comes with referencing to say there's a common law principle that I love so much that is always being attached to the trust is what we call conduit pipe principle. And hence I'm saying tax efficiency structuring, right? So, and you will see that with that principle, it actually shows you how you end up leaking the control that is normally in the hands of trustees to the enjoyment on the other side that is normally with regard to the beneficiaries, right? So that's pretty much what we're going to have in this session. Go with me on this journey, and then if you've got any further questions, you're more than welcome to reach out to the office, or can you always reach out to me also on WhatsApp, and then we can have a discussion on and clarify some of your questions, right? So now, this first presentation, I said beware. Now, let's think about it. This is the founder. In the minds of the founder, he say, I want to have a trust. Why? Why is this founder? What are the intentions of this founder? Why do they want to start a trust? And as a trustee, you need to ask yourself that particular question to say, why is this founder wanting me to be a trustee? Or you might find the situation where you are a founder and equally so as a trustee to say, what are your intention of forming this trust? And I'll tell you why. Because the intentions, if the intention is to blur the lines and taking advantage of the notion of the formation of the trust, which is a separation of of control of the assets and enjoyment, and you blur the lines, you will see it in the administration of the trust, where the founder actually blurs the line. They still maintain the control, while at the same time, they still enjoy the benefits of the trust. Can you see? Nothing really changed. They just simulated the relation. They just simulated the transaction in such a way that it kind of looks like they separated the whole thing just to get the protection, the asset protection that a trust comes with. But in reality, in substance, the facts remains the same. Now, as the trustee, it's crucial to maintain the conflict of interest and manage them. Manage your conflict of interest. You cannot be seen to be conflicted as a trustee when you're acting as a trustee in a particular trust. You always push the interest of the beneficiaries at all times. One of the things that also needs to be mindful of is the creditors. Guys, as trustees, be careful, because creditors will always say they've got a very strong memory as compared to the debtors, right? They will remember that you owe them. And you know why they're going to get you? If they really want to sue you, they'll look at how you did your trust administration. That's crucial. So make sure you're doing proper trust administration. By the way, the trust, it also helps with dealing with family feuds. They fight over wealth. We've seen so many stories about families fighting over family wealth. Family feuds can erupt. Two people married for 20 years can divorce tomorrow and bring you into the whole war as the trustees. And if you have not been doing your task well as a trustee, you might find yourself being compromised. You may find yourself having to deal with these dynamics. Again, as a trustee, when there are family feuds, whose side are you going to take? So, which means that as an independent person, you need to be objective and act in the best interest of beneficiaries. Act in the best interest of the trust and the beneficiary, which is why it's crucial. You can't be seen to be favoring one person over the next. So again, your biggest person, tax. Make sure that the tax affairs of the trust are up to date, guys. Make sure that the trust, as soon as it's registered, it have a trust tax numbers is there, because it's the law, is the requirements to ensure. Make sure that a trust, as a professional taxpayer, it submits those professional tax returns. And that's why even when the trust is dormant, so-called trusts that are not making money, it's still requirement to actually submit those professional tax returns, even if you're going to report and or resubmit as nil amounts, but you still need to ensure that you comply with the tax legislations. As I said, you can have a different bloodlines. The trust normally, as families grows, those beneficiaries as descendants can be actually potentially be from different bloodlines. And we all know the more there are very different types of bloodlines, the riskier it gets as family feuds can actually erupt. How do you deal with that? So that's why continuously you need to start shifting things around as trustees. As long as you're acting in the best interest of all the descent or the beneficiary, rather, in this context, then you'll be able to manage the family feuds. Don't get caught up in the family. Don't be seen to be favoring. Your guiding principle is to always, always, always act in the best interest of the beneficiaries, right? And maintaining that will actually help you a lot as a trustee, right? So that's very, very, very crucial. So these are typically things that you'll be dealing with on a day-to-day basis. As long as you're a trustee, you need to be mindful of that. And as independent trustees, some of us who are acting on this, we always have to make sure that we also maintain that and stay away from having conflicts of interest when it comes to trust, and be mindful of the creditors that, and making sure that the trust administration is up to notch, because should we fail to ensure that the trust administration is that, we can even end up being liable personally. That's how hectic it gets. And also be mindful of the intentions of the founder, or rather, yes, the founder in this context, because we don't want to be a sleeping trustees and we just rubber stamping all his decisions that will be blurring the lines, and that will actually be compromising the very notion of forming a trust, which is to ensure that there's separation of the trust, control of assets, and that of enjoyment that comes with that. Of course, there are kids and the beneficiaries that we need to think of. The people might be mobile, people might be staying in different parts of the world. We need to be mindful of things like that. How do you also ensure that this wealth actually continue to the next generation? That is, the trustees needs to always continuously worry about that, act in the best interest of the beneficiaries, right? Now we keep going, right? Why trust? So you'll typically find the trust founder at the top. Some of the best trusts that we've seen, you find that the founder can be the grandfather who's find this trust for the better or the enjoyment of the grandchildren. You can still be a founder, the first founding, and you can still be a beneficiary, but there's a bit of more steep requirements where you find that you also need an independent trustees. You need to let go of certain things to ensure that the very notion of separation of enjoyment and control of assets is actually clear and the lines are not blurred. So it'll be a founder at the top who finds a trust. We just use the family trust in this context just to be more relatable. It can be any form of a trust, will always be having a founder. Then there'll be nominated trustees, and then those nominated trustees obviously get appointed by the Master of High Court, provided obviously they also qualify according to the Trust Property Control Act and other relevant statutes, right? So those trusts get bestowed or get given control and ownership from legal point of view of the trust assets. It gets handed over. Legally speaking, the trustees have control and ownership of the trust assets, right? And they act on behalf of that particular trust estate for the betterment and the enjoyment of the beneficiaries. So it's not for their own self-enrichment. Be careful of that. It's not for their own self-enrichment. They just have legal control and ownership of this particular trust estate so that they act and manage that. Can you see that together these trustees having this control and ownership of the trust assets? Can you see now it brings me to another conversation to say, they then need to do what? Act jointly, which is where is going to show us during the administration of this particular trust, where the trustees acting jointly. By the way, acting jointly doesn't mean you don't apply your mind independently. No, you need to be seen to be deciding on factors or deciding on issues that has to do with the trust together. Even though, yes, according to them, we look at what the trustee is saying, because the trustee can say majority decision prevail. But the fact of the matter, even though the trustee says that the majority rule prevail, you still, because from statutory point of view, you need to be acting jointly because, like I said, the trust assets are transferred to the control and the ownership of the trust assets get bestowed to the trustees. So you will then firstly, they do what? Act jointly. And then from there, you do what? You decide based on what the trustee is saying. Can you see now you'll have satisfied that provision? And then if the majority says, we are buying this particular property or we are disposing this particular property, then in that context, then the minutes will document that to say that was taken. By the way, a decision of the trustees is simple. It's how do I put it? Let me put it this way. A decision of the trustees is a decision when it's reduced to a resolution. The minutes will put the discussion of the meeting, but the decisions are validated by a resolution. I'll repeat that. The decisions of the trustees are validated by the resolutions. This is why from a deliberation of any form of transaction that a trust needs to enter into, it needs to be held. The trustees jointly need to deliberate on every single transaction, as long as there's a signature, as long as a trust is part of a specific transaction, trustees needs to deliberate on it. Why? The very same notion where I said the ownership, because the trust assets are bestowed to all the trustees jointly, they need to act jointly. However, once they've decided on the particular decision, reduced to the resolution, they can have another resolution to say, yes, we decided on these facts, we decided on this particular transaction. However, we're delegating Shiliboy to go and sign on behalf of a particular trust. That's fine, because you all acted independently, you all decided together to go ahead. However, you just going as a representative, say, this will represent and sign, everything is binding. That's perfect. You don't want to be in a situation where you just wake up because you think you have been the founder, and then next thing you go and find yourself, how do I put this? You go and find yourself just deciding on entering into properties, signing OTPs. That transaction is not legally binding, because who capacitated you? Which capacity do you have? Who gave you a decision to go and sign that OTP on behalf of the trust? Who approved? Who gave you the resolution? No one, right? This is where most people get it wrong. Can you see that you haven't separated the control and the function? Because in that sense, you're in charge. It's the same as you going and buy a property. And this is where loopholes that creditors and everyone, even SARS, if they want to say, we actually had an alternate control of this, the trust doesn't exist, it's a sham. Let's bring everything here upon death, and this is part of the estate duty, then they tax on that. So make sure that you separate, you discuss every time there's a transaction that you potentially want to look into, bring it to the attention of all the trustees. Let's deliberate, decision must be taken, and then we keep on going. This is why you find that in some cases where there's an operational issues, let's say there's municipalities that needs to be paid, you know those sort of regular recurring payments, right? You know them. Let's say you are in property, like specific salaries and things like that, and that are recurring. In order to avoid having too many administrative burden, a budget can be prepared and say at the beginning of the year, this is how much, or this is what is going to be paid. Says every 6 months, for argument's sake, if you can't estimate, and then a resolution can be passed to say, we deliberated on this budget and we delegate that as long as payments are as it is, so and so can release the payment. Done. You are number one, right? Can you see? Now, who has to benefit and who has to enjoy? It's beneficiaries, not the trustees. No, trustees cannot self-enrich. That's why initially I said, be mindful of being in a situation where you're conflicted. You can't find yourself in a situation where a trust has to dispose the property and the market value of the property is 2 million and you want to sell a property for 1 million because your company on the other side is going to buy this particular property. Is going to buy this particular property. You can't find yourself in that position, right? So you need to avoid those type of situations. And that's quite crucial to ensure that you're not conflicted as trustees. You always act in the best interest of the beneficiaries. No one can benefit from the trust assets or incomes if they're not beneficiary. So that's also crucial and to bring. So this is typically the notion of the trust, separation of the control. And so that's what we always say is one tool or one investment vehicle in the country that ensures that the separation of the two, where you can protect the assets and bestow the whole ownership into someone else, but then you're still benefiting. Do you see? That's what we always say. The foundation and the crucial and the reasoning behind the trust formation, it's about that. The rest, they just come. But this, if you don't get it right, trust me, you'll lose the wealth because you did not separate, you blurred the lines. Don't blur the lines. Right. Now, let's try to understand the court cases. And I'm going to just try to list some of the things and try to do the discussions. What have been the court cases, lessons that we have seen out there? Because there's just so much of court cases that you can actually pick up and read and things like that, where you can actually keep up with them. So now, it's crucial as a trustee that you understand the trust deed. Why am I saying that? Trustees cannot act, or trustees are actually empowered by a trust deed. You cannot decide or do things that are contrary to the trust deed. And also, you cannot act, right, in things that actually are not as per the trust deed. You can only do as the trust deed is saying. That's it. You cannot be taking decisions and resolutions while the trustee is not empowering that. You can't. If the trust deed is saying this trust is to invest in properties, and next thing tomorrow you want to invest in mining, it can't be done. That's not what the trust deed is saying. So be careful of that. There's also an issue, the clause where it says the trust needs to have minimum number of trustees. It can be 2, can be 3, can be 10. Be careful. If the trust at some point does not have that minimum threshold, is not having a capacity to act. So a trust will cease to be capacitated in a loosely, if I may borrow the word quorum. You don't have a quorum. You can't make decisions. So it's the same thing. It's the same principle, if in a way. If you've got, say, 2 minimum trustees need to be in the office, if we don't have that, from functionality point of view, a trust cannot enter into any form of decisions because the office of the trustees needs to meet that functional provision. So be mindful of that. What is your trust deed saying so that you guys are capacitated to act and bind the trust, right? Sub-minimum of trustees cannot bind the trust. Like I said, I just explained that. So the issue of independency and independent outsider, like I said, independent trustees cannot be just a sleeping trustee where you come and say, Shilipo, just stand here. I'm buying here. Hey, Shilipo, stand here. Hey, Shilipo, can you pick up this and sign for me quickly? Doesn't work that way. That's not how you're going to preserve wealth. Take a step back. When you've got wealth, when you're building wealth, you need to be calm, right? Do things in a proper way. Because rushing, you're going to miss these steps. Tomorrow, the creditors are going to come. Tomorrow's house is going to come. You say, by the way, where's this resolution? Where's this? Where's that? You lose wealth there. So let's guide you and make sure that you actually follow the right things. Remember, I mentioned the fact that trust assets moves into the ownership and the control of trustees. Why didn't I say trust? Because from legal point of view, trust doesn't have legal personality as versus companies and other things. Trust does not exist from legal point of view in terms of legal personality. Hence, what exists is what we call trust estate. And who controls and who owns that from legal point of view is the trustees. Trust only exists from, let me borrow the legal personality when it comes to SARS. SARS sees tax having the legal persona. From tax law, it does. But from the general legal principles, trust doesn't exist. It's the trust estate that exists. that is controlled and owned by trustees. That's why fundamental is crucial word that the trustees act jointly, because if you and I own property, you can't decide and manage the property alone. You can't, unless we delegate it to you. Can you see where we are going with the principle? So the same way, because we jointly own and control the trust estate, we need to act jointly all the time. Yes, we can delegate. Yes, we can move things and say this so and so Shilly boy or so and so can actually represent the trust after we've made a decision based on resolution. Like I said, assets, when they moved in that particular trust, they vest on trustees. It basically it goes back to what I just said about the control and ownership. Administration by the trustees, of course, vest into trustees so that the trustees do the whole administration of the trust estate. That's very, 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 you get that right, you'll preserve the wealth for generations to generations, right? Trustees join ownership of the trust act estate, like I said earlier, act jointly. It's crucial, guys. That's how you're going to actually preserve your wealth. I said earlier on, if you remember, I said, you cannot act or do things that the trust instrument does not empower you to do as trustees. Doesn't matter. You cannot be seen to make those type of decisions that are not empowered. You get empowered over and above the statutory law, but you derive powers. You derive powers from the trusted. Read your trusted, please, guys. Read your trusted. Let it be your bedtime story book now and then, just to familiarize yourself with what your trusted is actually saying, because that's when you're going to derive powers. That's how you're going to act actually using that trust instrument, right? These are some of the things that the courts are looking into whenever there's a trust case. They'll look at all these things. There was the minimum trustees at some point not being met, and what did the trustee do? Did they attempt to appoint? Were they entering into transaction even though the minimum trustee number was not met? If you have been doing that, you'll find yourself in a problem because you are running the show incapacitated. Why making sure that the trust is actually not even meeting sub-minimum trustees, but you're busy entering? You can't bind the trust. But you can even end up being held several liable for those type of transactions. Do you see how you can? Because you're not familiar with the trust deed. You're not familiar with the trust instrument. Please familiarize yourself with that, right? Some of the court cases lessons, like I said, trust deed, bind the trust estate. As long as we act based on what the trust deed is saying, we're going to bind the trust estate. Are you with me? So we also, like I said, it goes with the capacity defining provisions, be mindful of them. What does a trust deed say about the decision? Do you have a capacity? Do you meet the minimum requirements of the trustees that needs to exist? No. Then it means you're not capacitated. Why should you be binding the trust? Because you needed 2 existing trustees minimum, right? But from a legal point of view, if a trust, you can ask a question to say, but what happens if, let's say, in the middle of something, one of the trustees passes on, and we're in a process of removing them or obviously replacing them. Let me use the word replacement. What happens? Does that mean, because you don't have capacity during that time to actually bind the trust, so it ceases to operate to a certain extent. But what happens to obligation? Do they follow? No, they don't. And can you see that it goes back to, imagine then if we have done the budget, the necessity of having to do a budget, and then so that we already delegated that decision to say certain obligations still needs to be paid. So such kind of a thing, it's also crucial. That's why you need to be on top of your administration so that things like this don't catch you off guard, right? We are saying, looking into the acts and the statutory, what the statutory is saying around the trust, there's a section 7, subsection 1, that gives the master a default power to appoint. We all know you can nominate trustees as you start the trust, but master has default power to appoint trustees. And if in a case where you're not meeting the minimum trustees in the office, the master can actually instruct you and appoint someone as a trustee. But obviously there'll be some sort of a conversation and communication to that effect, but the master can then appoint someone as trustee to ensure that the trustee has a minimum required trustees. Independence of judgment on the part of the trustee, an indispensable requisite of office. I said earlier, as much as is the crucial that the trustees act jointly, does not mean that I must just agree to everything that the other trustees are saying. I still need to have exercised my own independent judgment as a trustee. Each and every, you can't be in a situation where you are mother and the father, you in a bedroom, you're deciding about the transactions of the trust, and next thing you don't tell your independent trustee, you don't tell your, let's say even your children is one of the trustees, you don't tell him, you're like, listen, we're going this direction. You never consulted, it was never made part and parcel of the meeting. That is not how things work, right? No, the fact that you are a founder does not, it means nothing. So yes, you are a trustee, you're the same as other trustees. Decisions needs to be taken. The independence of each and every trustee needs to be visible. They need to apply their own decision. They need to apply their own mind so that it's shown that there was an element of independent judgment on any form of decisions and deliberation of all the trustees. Hey, be mindful. If it happens that you're sequestrated, can you be an independent, can you be rather trustee? No, you can't. So be mindful of that. Once someone is sequestrated, cannot be a trustee. The primary responsibility for compliance with formalities and for ensuring that contracts lie within the authority confined by the trustee lies with the trustees. What we are saying here is, you need to ensure it's still your responsibility that all the contracts that you guys are entering into as trustees actually comply or are actually empowered by the trust deed. Failure to this, we're seeing court cases actually, where if you were to enter into a transactional contract, that a trust deed is not actually empowering you to do this, you might find yourself personally as a trustee liable to any form of consequences that can, we're seeing actually courts actually starting to say, you know what, we're seeing a lot of founders creating trust and then entering as they please, not even observing what the trust deed is saying, and next thing they get into trouble, and then they want to invoke the trust deed. No, you did not comply with the trust deed. You can actually end up, and there's some they even claim, say no, they can even use the capacity issue, say the trust did not even have enough minimum number of trustees, therefore the trust cannot be bind in the, yes, the court will say, yes, you're right, the trust did not have a capacity to bind itself, but actually you are personally liable for this transaction. Can you see what happens? So please do things the right way. Be patient, do things properly. I beg. So these are some of the issues that we are, and if you don't have understanding, guys, so far, please reach out to us and we can clarify some of these issues. Right, let's go. Now, what are the common mistakes that we are seeing in practice? Founders acting without consulting other trustees. I said it. Someone say, listen, I started this shillabot, send your WhatsApp. Please sign this quickly. I'm not gonna do that. I'll tell you, I'm not gonna do that. Or tomorrow, the trustee just withdraw the money, 500,000 out. you are just getting yourself into lot of troubles. Please act jointly with other trustees. Consult, have a conversation. It's actually nice, because the more you deliberate into issues, the more you grow, the more you learn, and then it's become more conversational, and you get empowered, and you grow as an individual, and as also as a profession. It's actually nice to engage, and you learn a lot on preserving wealth, because that's actually a key thing about the notion of separation, is to preserve wealth. So why not engaging? Don't blur the lines. The moment you blur the lines, you don't consult. Can you see you blurring the key fundamental reason of the notion of the formation of the trust, of separating the two? You are just bringing them together because you don't consult anyone. You control, you benefit. It doesn't work, right? Reserving powers in a will or interviewer's deed. We've seen that, where the founders actually still have the control of the functionalities of the trust through their wills. Guys, please be mindful of things like that. Lack of trust deed compliance. Like I said earlier, I invest. Guys, comply with trust deed. It's your Bible, if I may use that way, if I'm allowed, right? Well, everything else remains as before. Like I said, someone comes and say, I'm going to be investing in property, so I've got businesses. Can I move into the trust? Yes, okay, cool. We do the tax planning, we move everything. Sharp. But how they are doing the trust administration, there's no difference as compared to the before. So they're still controlling, they're still influencing everything. They run as they show, as they please. Can you see that there's no difference between the two? So if there's that, trust me, you're just digging your own difficult position, right? Ignoring central notion, act on the best interest of others. Okay, as a trustee, you cannot be seen to ignore that notion. That notion of separating control and ownership. It's you're responsible for this trust estate, but you're acting in the interest of who? Who has to enjoy the trust estate? Beneficiaries. So you cannot be seen to be ignoring that. No, because you'll blur the lines. Are you with me? There are certain mistakes that we've seen. Like I said, control resides with beneficiaries. Courts are not favoring things like that. You can't be a trustee and beneficiaries deciding as you please. It's not going to fly. So, and that's when they introduced the necessity of independent trustee, because why they're saying this, why they discourage this, is because the control residing with beneficiaries, you can't hold yourself accountable, and you'll blur the lines of the notion. You are undermining the notion of the formation of the trust, of acting in the best interest of others. So people typically tend to do that, where they actually end up not anymore acting in the best interest of the beneficiaries. So it's also crucial to ensure that such kind of a decision is actually, you are able to still continue to be seen to be acting in the best interest of others, who in this case is beneficiaries. So it's crucial to ensure that you are able to maintain that, and you'll only be seen by doing that if in the context of where the control does not reside with beneficiaries, because that can actually indicate that you are you're more likely to undermine the very notion of act in the best interest of others, which is beneficiaries in this context, right? As I said earlier, when they actually, the courts found these, they recommended, obviously through the judgments, you say they will foresee or like to see the amendments of legislation. Obviously, they can't just influence like, but then you can tell from the reading of the court cases to say they felt that when the control is residing with the beneficiaries, who also happens to be independent, who happens to be trustees, the very notion of the formation of the trust, it's blurred, it's undermined. And to protect the very founding principle of the trust, which is centuries and centuries old, they had to bring someone who's an independent outsider. That's where the independent trustee comes in, who all trustees act the same. Can you see where the wording of independent comes in? Someone who's going to come and observe and say, listen, I don't think this is how things should be done, right? I don't think that's how you're blurring the lines, because you're undermining. Because if you think about it, independent trustees are custodian of making sure that the very notion of acting in the best interest of others, or rather to maintain the separation between control and the enjoyment of the trust estate, that's where the independency comes in. So you can't be seen to be conflicted. You can't be seen to actually be undermining the very same notion you are actually appointed to actually being doing that. So the master issued directive in March 2017 through after so many court cases that were actually resulted in judges actually encouraging that there's the need actually to protect the notion of the formation of the trust, to ensure that there's at least a trustee that is independent among the other trustees. You will typically find that the master will not register the trust if the independent trustee is not appointed, because it's a legal requirements now based on the directive that is issued by the master in 2017. So where this the independent trustee comes in is normally where trustees are beneficiaries and the beneficiaries are related to each other. You'll think about it, these are normally family wealth space where most of people create family wealth, and then they find themselves actually being the beneficiaries and at the same time acting as trustees. So will those people observe and respect the notion of formation of the trust? Some, they would claim that they can, but then we've seen the history have shown us, then the court actually shown us that such situation actually it's not it's sometimes it doesn't get observed, right? Trustees could enter that transaction as per the trust instrument. So you will find that also those trusts are actually able to enter into that obligation, like raising bond and things like that. So if your trust is going to embark on that, then to protect even the very same creditors, because we've seen in court cases in the past where people try to invoke specific capacity provisions to say they were not capacitated and things like that. So to protect the fiscus and to protect the commercial arrangements out there, that's why they're emphasizing that if your trust is going to be entering into debt obligations, then you need to ensure that there's an independent trustee who's going to respect and observe the very notion of forming trust. And that's quite very, very crucial so that we don't find undermining certain commission. And that's why it also was being emphasized from the law point of view, court cases, to say, is the trustees cannot come and claim and use the fact that they were not actually empowered by the trustee, because the responsibilities that they still lies with them to ensure that any form of contracts that get entered by them, it's actually in compliance with this very same trust instrument. Can you see that it actually gets thrown back at you as all the trustees? This is one of the reasons why we need independent trustees, the very same, to protect the very notion of centuries and centuries of years of why trust exists, to act in the best interest of others, to separate ownership and control to the enjoyment. Where the trustees and the beneficiaries are one and the same thing, and they are related, that the court found that such notion actually has been undermined over the years. And then as a result, influence has been there, and then the master decided, no, in that case, we need all the trusts registered to have an independent trustees. That's why the likes of Intaget exist, to protect and preserve the same century and century of years of this wealth preservation, or this wealth principle that preserve wealth from one generation to the next. So if you undermine that, but you say you want to have an intergenerational wealth, I'm not sure what we mean when you say, someone says, I want to have an intergenerational wealth, but then they undermine this very same principle that should be actually helping them to get to the next level, right? Cool. So now let's go to the sum of the expectations of independent trustees. This is where it's getting very hectic, and we always emphasize that we as independent trustees, does we need to be professional? No, it doesn't have to be a professional person, as long as that person can actually be able to realize and make sure that the trust functions are all properly actually aligned, and make sure that the trusted provision are observed. But can you see that you will typically then need someone who's practicing in that space, who has an experience and who's also sector focused? Because think about it, how would you actually be understanding the provisions, say in the mining industry, if you are not really a specialized independent trustee in the mining industry? So this is one of the things that has been actually recommended, or as part of the directives, that, and also case law that we have seen. Then another thing, independent trustees, that the conduct of other trustees who lack sufficient independent interest in the observance of substantive and procedural requirements arising from the trustee can be scrutinized and checked. And this is why we're creating things like this, to make you aware that please help us. Because if we're starting to see that you're not observing the very same trustee that should be protecting you, and we need to highlight that to you, so that we would bring you back into the rings of trustee, right? Failure to observe, breach of trust. So we need to ensure that we don't fail into that. And that's why we are professional, and one of the things also is that's why the fees of independent trustees needs to be paid, because the very same thing that if the fees, it means the basic thing of failing to actually making sure that we get paid for the fees, it's a very thing that is contracted and trusted, by the way, because the fees needs to be guided within the trustees. So if they're not paid, it means also by the very same thing, we are not actually being complying with the trustee. So this is it's a court, it's a case law, guys, and it's a master's directive of why the history of why the independent trustees actually is there, exist. These are crucial statutory things that you can tell. Maybe just to summarize back again, is no need to be a professional, but the reality is that you want someone who can comprehend and understand some of the matters, and that's what typically you'll find accountants and chartered accountants and attorneys typically acting as independent trustees. Responsibilities realization and trust functions properly. So it's, like I said, ensure that you've got, as an independent trustee, ensure that the trust functions properly. Resolution, things like that. Like I said earlier on, trusted provision observed. I said it. You cannot act if you're not empowered by the trustee. So you cannot be seen to do things that are not in the best interest of the trustee, right? That the conduct of trustees who lack sufficiently independent interest. So manage those conflict of interest, like I said earlier. All trustees make sure that they're not conflicted, make sure that we observe and make sure that things are actually scrutinized and checked and balances, and that's crucial. So work with us, guys. Let's all work together so that we preserve the wealth that you're working so hard for, right? Now, this is the principle that it kind of fit into the notion of, maybe let me start it here, and I'm going to show you from here. This is where the principle comes in. The very same trust, let's say this trust owns these assets. These blocks is assets. Are you with me? The money flows into the trust. Remember, the trust is these blocks are the trust assets, but then is the trust estate that is under the control and ownership of the trustees. Would you agree with me? Right. Now, there's an enjoyment that these three little ones, sometimes also you and your wife, can be beneficiaries of you are beneficiary of this trust. Will you agree with me? Now, there's an olden age provision called conduit power principles. Is the one that allows us as trustees, after we deliberated, again, functionality of the trust administration, where it allows us to actually deliberate and decide to say we're distributing, if in this case it's a discretionary trust, we're going to deliberate and decide and say so much has to be distributed to the beneficiaries of the trust. We're going to use a principle called conduit part principles, and that's why it comes and link the very notion of acting in the best of interest of others, which is the beneficiaries, and also linking the concept of control and ownership to the enjoyment. Can you see we link that through conduit part? That's why it's always protected, this provision, this common law, because should it be stripped away, it can actually potentially have an impact on the very olden age centuries notion of the formation of trust. But I'm not saying that it can't be amended. I mean, law can change, but the reality, can you see the historical context on where all these things comes from, right? Then eventually, then the benefits goes to the beneficiaries. Can you see how everything else comes all together? When I always emphasize this to say you can plan this in, there's a conduit part principle. We are trying to summarize it quickly so that it's just a mixture of the conduit part principle meeting the very same notion of the trust assets and the trust estate, meeting the enjoyment, the control and the ownership of the trustees, owning the trust estate, moving into the enjoyment of the beneficiaries, the very same trust. I hope it's clear now, right? If you've got any further questions, please, you're more than welcome to reach out to me, or for that matter, you're more than welcome to reach out to the office, and we can assist you as our independent, as we act as independent trustees, and help us to do the proper things in terms of trust administration. That's why we'll always share with you content all the time to ensure that you're empowered as the fellow trustee, but it's also for you to speak out to us. Don't enter. I think don't enter into any form of transaction. Don't go and act as representing the trust if you've not been delegated to do that. Don't do that, please. It doesn't matter. Don't put a signature anywhere. Don't put any signature, or don't be seen to purport to represent the trust if you don't have any form of a delegated authority for that particular thing. Don't enter into negotiations when you have not even been empowered. It's not even only reserved for signature, but don't be seen to be representing a trust anywhere, through conversations, anything, without having been delegated for that matter. Maybe let me use that general statement because it encompasses everywhere, right? So please, that will help us to preserve the very same wealth that you're trying to build for generations to come, right? Now, this is the end. So you're more than welcome to reach out to us as Intergen, together with Tax Edu, who does the tax research all the time, like I said earlier on. So yeah, it's we are grateful. Thank you so much for being our client, and we value your business, and we're looking forward to working with you. And yeah, cheers. Thank you.